Right, we are on record this afternoon pursuant to a request to terminate parental rights. And the names of our participants, please.
Good afternoon, Your Honor. Ariel Berger here in the guardian ad litem.
Nastasia Thomas, counsel for the department.
Caitlin Young, Department of Health and Human Services.
Your Honor, Elias Mwada appearing on behalf of the mother, Bailey Demansky.
This is Bailey Demansky, the mother of BS.
All right. So we have had some pretty regular reviews in this case on this particular parent. Our typical protocol, Mr. Mawad, is to consolidate the request for a determination on a petition for termination of parental rights with review, because of course, when it's concerning the part of the statute that requires me to look at whether or not there's been sufficient progress made in the time frame, it seems appropriate. Also keeps us from relitigating everything that's already been reviewed over months and months. Do you have any objections or any preliminary issues that you'd like to raise on that issue?
Not on procedure, that's fine, Judge. I would agree with you, that's fine.
All right, so you may then hear some objections if we start going too far afield from what is the most recent information.
Fair enough.
And I do allow, for purposes of building, laying foundation, and if you're making a point, some exploration into that. But I just wanted to preface our hearings with a little warning on that point.
Okay.
Any other preliminaries before we get started?
No, Your Honor.
Any comments, opening statements?
I will waive opening, Your Honor. Thank you.
I'll wait.
All right, your report.
Yes, thank you, Your Honor. I was able to visit with the minor child this reporting period. I was also able to go out in person in November, so I got to mix in a couple virtual with in-person visits. But I was able to visit this morning actually virtually and placement reports that he is growing like a weed still. He's in the 97th percentile for height and weight. Definitely looks more like a 4-year-old than, the toddler he is, but he no longer is in need of services or speech through Help Me Grow. So he's been reassessed for that, and they do not think that he needs those services anymore. He has been getting sibling visits. He was able to visit with his siblings over Christmas. And overall, he is doing very well there. He did make it like 3 or 4 weeks without getting sick this time, but has a cold right now. So that's kind of on par for the little guy. But he is extremely bonded with this placement. And he's been there for quite some time at this point, since infancy. So it's been great to watch him learn and grow and be able to express himself there. He loves water. He's always playing with his water toys. He's playing in the sink, quote unquote, doing dishes, just splashing around and making a mess, which is wonderful. But at this time, I am in support of the petition for termination. The likelihood of this child being adopted by this family is very high. They, have expressed their wishes to do so above guardianship and above the other options that we have discussed with them. But at this point, I am in recommendation, and I would say other comments for closing.
Thank you, Your Honor. If Ms. Young can be sworn in for her report.
Come on up to your stand. Go ahead whenever you're ready.
Thank you. Ms. Young, how are you familiar with this matter?
I've been the assigned foster care worker in this case for the past year.
And did you prepare a court report for today's hearing?
I did, yes.
And this hearing is only as it relates to Ms. Demansky. Are there any other documents that you provided the court report other than the case service plan?
I think it was just the court report and the case service plan.
Perfect. Are there any updates or modifications that need to be made to the court report?
There were just a couple minor things. I had mentioned the other minor child. That was an error. I thought I had taken that out of there. But it had just been some recommendation for that other minor child who was closed already on this case. I was not aware that he was already completed speech services, so that's another update. I can put in as well.
Throughout this review period, how would you describe, and again, we were just here on December 6th, so it's not been very long, but how would you describe Ms. Demansky's, compliance with and benefit from her case service plan?
I mean, she's as compliant as she can. We did meet on January 12th, just to kind of go over the case service plan, discuss any updates that she had on her end, as well as kind of discussing how kids were doing. She did mention a plan that she had arranged with the other child's father for when she is released to do some parenting times, supervised in a controlled setting, just so that she can kind of maintain that relationship with her other child. So we did discuss a little bit of that. We discussed court and just kind of, what the recommendations and kind of what to expect for today's hearing.
In general, what would you say is the risk of harm to the child if the court were to order the child back into the mother's care and custody today?
At this time, because she is incarcerated until at least June, she's not able to provide a safe and stable environment for him in her direct care. He is in a relative placement since the very beginning of this case, who's been able to kind of maintain some of that contact. So at this time, that risk would be substantial, pretty significant if we were to try to return at this point.
To the best of your knowledge, about how long has this child been removed from her care and custody?
The child, I believe, was removed on 3/26 of 2022, but she's not had any contact with the child since May of 2023. Visits were suspended.
Part of the petition, and part of the grounds that the court must look at is whether the conditions that cause the child to come under the court's jurisdiction have been remedied or rectified. The reason this court has jurisdiction is for child abuse. Is that correct?
That's correct.
And to Ms. Szymanski's credit, she did comply with the case service plan throughout the duration of this case, correct?
That is correct.
And that is acknowledged in the petition, correct?
Correct.
So can you help us understand the second part of the analysis of whether there remains a risk of harm to the child and whether those conditions have been rectified?
Because visits have been suspended back in May, right before she was incarcerated, she has not had contact with this child outside of writing letters. She has provided consistent letters starting in about October to provide to me for the children. She's drawn some pictures. There's a short letter that she's written for each of her children. So other than that written correspondence and the communication that I've been able to have with her, she has no contact with the minor child. He's about 2.5 years old and has not seen her in a significant amount of time. Due to not having that relationship and that bond currently, he would be at risk going back into her care. Like I said before, she's incarcerated until at least June for these child abuse charges. Oh.
In the psychological evaluation, which was presented a significant amount of time ago, but during this review period, have any of the recommendations been completed?
Just during this review period, we haven't really been able to do a whole lot as far as the case service plan. She doesn't have access to like formal therapy services or really the recommended book that Dr. Hagen had recommended in his psychological. She doesn't have access to that material. So she's not able to really work on the specifics. She's able to kind of meet with a mental health provider through a kite service through the jail. So as needed. And that's, if she's having any issues that she needs to address, she'll put a kite in. If there's any medical things, she'll be able to do that. But as far as, providing supervised and structured visits, we couldn't do that. Stabilization of her anxiety, consult with possible medications. I mean, she can do that through a kite. And she's been able to, kind of address some of that mental health. But as far as, doing a parenting training. She completed that prior to incarceration. But to my knowledge, they don't have parenting education currently in the jail. And then again, completing the Keeping Families Together book material that Dr. Hagen recommended. That's not something that she was able to complete while incarcerated.
Prior to her incarceration, when she was completing like a parenting education program, do you believe that she was able to demonstrate benefit from that program?
She was showing some benefit from that. She was in a therapeutic structured visitation with Renee Moore's office. And then we had moved visits over to our office to provide some more structure. And then she was also doing visits with the other minor child closer to where he resides in a different therapeutic setting. So yeah, she was able to demonstrate some structure and stability in those visits. But again, like I said, she hasn't been able to demonstrate that in a significant amount of time.
During the case, was you able to exercise unsupervised parenting time?
No.
Into Ms. Demansky's, again, credit, she did have employment that was pretty steady prior to her incarceration, correct?
That's correct, yes.
And do you know if she's able to like have any employment type jobs while incarcerated?
She actually is. It's kind of a form of employment. So she's in charge of her unit, and in that helps she pay off her stay while she's incarcerated. So she's able to kind of help provide that structure within that unit, clean the unit, and do some other details there as well. And like I said, that pays for her fines, her stay while at the facility. So she won't have any fees when she is released.
And during this case, has she provided financial support to the child?
I think, I wouldn't say direct financial support to him, no. She's just provided letters and some pictures that she's drawn for him. I'm not aware of anything financially that she's been able to assist the family with.
And prior to parenting time being suspended, when she was exercising parenting time, did she come prepared with all of the child's needs?
She did, yes.
And there was no concern about her housing at the time prior to her incarceration, correct?
That's correct.
I think the $1 million question might be, well, what is the harm if we just wait until she's not incarcerated anymore and work towards reunification?
I think one of the biggest concerns is because she's not had any contact with this minor child in a significant amount of time, we would have to reintegrate her into this life, and it would be another significant amount of time before we would be able to move forward with the supervised and then to unsupervised visits and exploring overnights. He's already been in care for almost 2 years, and that's most of his life.
One of the best interest factors the court must consider is the relative placement. And typically that weighs against termination. And in this case, the relative placement is the relative placement on the maternal side for this child or paternal?
It's the paternal.
And prior to her incarceration, was there an adequate relationship that between Ms. Demansky and the paternal relatives that would support like spending additional time together, having some unsupervised time, engaging in family events together, or anything like that?
I think initially there might have been, but the more information that emerged through the criminal process for her criminal case, that really kind of hindered their opinion based on like what they heard. They're very guarded about having that contact with her outside of this case. They have a lot of emotion, and they have every right to have that emotion. She had harmed one of their other grandchildren essentially, and it's a lot emotionally, a lot for everybody.
One of the things that was in the psychological evaluation, and also I think speaks to one of the grounds we've asked the court to consider for termination, is the parent's conduct or capacity and whether the child would be harmed if returned to the parent's care. And in the psychological, there's an element that indicates mom is prone to being agitated kind of quickly for parenting purposes, and that she really needs to take inventory of her own past and her actions and all those things. In your time that you've worked with this family, do you believe that she's been able to do that?
I do believe that she's been able to work on some of that. She completed kind of an anger management therapy course through Catholic Charities, and that was previously submitted to the courts, but she did complete that course. And you know, she was able to kind of demonstrate during these supervised parenting times her ability, you know, to remain calm, provide a calm and safe and stable environment for the children in that setting. So she was able to demonstrate that for the 1 to 2 hour time frame that she was in these visits. We hadn't had a chance to explore anything beyond that time frame, so it's hard to gauge, you know, in a more, I don't know, like in a longer time frame of being able to parent these children, if she has adequately been able to use those skills in those settings. If, you know, the minor child became agitated, or you know, there were some other concerns that, you know, that might irritate her. You know, it's hard to say how she would respond in that setting without being put into that scenario.
As it relates to the suspension of parenting time, was that at the department's request?
No.
And at that time, did the department or through you, did you have any direct concerns about her ability to safely exercise parenting time?
As an agency, no, we did not have that. Yes, we were under the understanding that yes, she was going to be sentenced shortly after, but we were still looking to have some sort of supervised parenting contact up to that point of her incarceration, because at that time we weren't sure if she was going to be serving jail time or not, but there had also been some other concerns that were brought up, some allegations that had come in, abuse of one of the older children that was not in her care. So there was just a lot of factors that kind of went into it, and also part of it was, you know, dad was not visiting either. So the motion that was filed by the guardian ad litem, it had indicated suspending both of the parent types.
One of the considerations that is becoming more, I guess, regulated by powers that be is permanency within a reasonable amount of time, and typically that's 12 months. You say that this child has been in care for almost 2 years.
Correct.
How old is this child?
The child is a little over about 2.5 years.
So for majority of this child's life, she has been with the relative caregivers, it's her primary caregiver.
Okay, that's correct.
Relative caregiver, are they a licensed foster care placement as well?
They are licensed, yes.
And are they licensed for adoption as well?
Yes.
And are they willing to provide permanency to this child?
Yes, they are.
And in this relative placement, does this child have his own bedroom?
He does.
And are there age-appropriate toys, learning materials that they have provided for him?
Absolutely, yes.
And have they made sure that he has gone to any medical appointments or followed up with any ancillary services such as speech or early on or anything like that? Has the part of, I think, the ongoing thread here for this child, those child's sick quite a bit. But that seems to be sort of some normal childhood sicknesses such as like hand, foot, mouth, or a common cold. Are there any concerns about that particular issue?
No, I mean, these are pretty common. He is in a daycare setting, so that's very common, especially at that age. And as you stated, I mean, he has been sick quite a bit. He's had multiple different things going on, but he always, you know, he overcomes it, and he always has a good attitude, and he's very outgoing. And like His Burger, he's growing like weed. He really is. He's a great kid. And overall, I mean, he's doing very well. Placement makes sure that he has all this specialty appointments. He's always, if he has any of these illnesses, he's seen by either urgent care or ER or the primary care physician pretty regularly as needed. So.
Thank you. Your Honor, I have no further questions of Ms. Young. I would move to admit the court report with the attached case service plan at this time.
I don't have any objection to the report. I just have cross whenever you're ready.
No objection.
Thank you. Court report and singular exhibit are received. Cross-examination.
Thank you, Judge. I have some questions for you. They're not a lot, and some of the questions we've gone through in the past. You know that there was a motion filed on May 23rd, I believe, 2023 or somewhere around there with allegations regarding Bailey, and then subsequently an order was entered stopping the visitation with the children, correct?
Yes, I am.
To this date, there's none of those allegations have been ever found to be true. Would you agree with that?
That is.
And then you also know that this hearing has been adjourned by nobody's fault. It's just been adjourned for various reasons, including the holidays, et cetera. That would not be Bailey's fault. You understand that, correct?
That's correct.
All right. And then she is sentenced, and she's been at the Lenawee County Jail, doing the best she can to carry out any services that she can carry out.
Yes.
You agree with that? Okay. I didn't hear anything unusual about her psych eval, other than you commented something on the psych eval. I just wanted to see, was there an issue with her psych eval, or were you okay with that?
And honestly, I hadn't had a chance to read it because it wasn't in our case file,
Okay.
and I wasn't finding it in our system until I had it forwarded to me before this hearing. So I was able to kind of read through, make sure that I had an understanding of kind of what the concerns that the doctor had. They conducted the exam, but there were some childhood trauma things that she had expressed to that doctor that may have contributed to a little bit of this. It's hard to say. So she's got some concerns that the doctor had expressed, and part of that was, maintaining a stabilization of her own mental health and anxiety, PTSD, and so forth. So, that was a big part of that concern, really stabilizing her mental health and making sure that she was moving forward, was able to provide that safe and stable environment for kids.
That Bailey is very insistent in her own mind on wanting to continue with any treatment regarding herself, even after she gets out of the jail.
She has expressed that, yes.
We talked about reintegration, right? You mentioned that. Reintegration happens a lot in this form, correct?
Yes.
Has reintegration occurred with other people that have been in jail and get out from CPS, or you guys recommend for reintegration for people that have been in jail in the past?
And it is possible, yes. We would just need to ensure that it was in his best interest, and really take a look at different factors, with the length of time that she's incarcerated, their relationship, their bond that they have, and make that determination. Is it in his best interest to continue to try to formulate a bond? So those are just some of those factors that we have to consider.
Well, I know the child's two and a half.
Yeah, about 2.5.
Very young,
Very young.
right? Probably doesn't remember the 1-year-old area. I don't remember what I did when I was 2 years old, correct?
Correct.
So isn't it easier to reintegrate that type of age with the mother more than maybe an 8-year-old, 9-year-old?
I mean, it really depends because everybody responds differently at those ages. So it really depends on a lot of different things. I mean, it would depend on how much he could recall.
Let me ask you this: the standard here is clear and convincing evidence. You're aware of that, right?
Yes.
And it's a burden between preponderance of an evidence and beyond a reasonable doubt. I'll call it the preponderance of evidence being the 51-yard line, the clear and convincing evidence being if it exists, the 75-yard line, and the touchdown being the beyond a reasonable doubt. Lines that obviously get a little effect on me, so sorry for the football language. But you can't say that with clear and convincing evidence that reunification could not occur with this child. Would you agree with that?
I mean, I wouldn't say that it couldn't occur, but it would not be in a reasonable amount of time. We would need a significant more amount of time to try to make that reunification occur.
And I would agree with you. I'm not telling you that. I just wanted to know it's possible, correct? For the
Correct,
child,
yes.
okay. You talked about her criminal matter, and you would agree that she has not only paid the price by being in jail, but she has really taken a lot of steps with mental health treatment to resolve out a lot of those issues that you talked about. You would agree with that, correct?
I would agree that she is working on those things.
Do you think she's a much better person now as far as her mental health than she was before? And I know you spent some time with her too.
Honestly, I feel that, yeah, she has made some progress. I think she's got some ways to go, just continue to work on that, because I think that's gonna be kind of a lifelong process. I mean, this case is kind of a rude awakening of, hey, there's some issues here. You know, a significant amount of injury was done, and, you know, it's really, it not only damaged the child, but also damaged her mindset too. So I think when Mr. Dr. Hagen had completed his assessment, he was assessing where she was at mentally following that incident, and, you know, really kind of gauging, you know, there's a big issue here with maintaining that mental health and stability, and she's recognizing that, yes, I have some issues to work through and I need to work through those. And that's where she's at.
No one can say by clear and convincing evidence that this would ever happen again. You would agree with that, correct?
It's not a guarantee that it would or wouldn't happen.
Correct. I would agree with you. Okay. I don't have any more questions. Thank you very much. Thank you. And I appreciate you taking my calls also when we talk about the case. It's very nice. Okay.
Thank you, Howard. You had testified that a part of the psychological evaluation was taking accounting of mom's own actions. Is that correct?
Correct.
At any point in time, did mom admit to you the physical harm that she caused this child to go through?
Not necessarily to me directly. She had admitted that, yes, there was some harm to the child, but at that time when I was interviewing her about that, it was more along the lines of, oh, he sustained an injury because he fell off a bike. So that was still pretty consistent from the very beginning of the case from that year prior. But it's since, you know, since that time that I had first met with her to discuss that, if she was going through that criminal case, so she wasn't really able to talk about that further.
Right. And did you attend the sentencing on the criminal case?
I was not available to, so no, I was not there.
And do you know if she ever admitted to the specifics of the physical harm that were caused to the child?
It was to my understanding, because I was able to play it back, that she did indicate, I think at sentencing, that she had done some physical harm, but didn't, I don't recall the exact details of what happened, but she had indicated some physical stuff that she had done.
Do you believe that what she admitted to and what actually happened were the same thing?
It's hard to say.
Do you
I
think,
don't know if we'll ever know fully what happened.
do you think that she downplayed anything?
Absolutely.
And are you aware of any permanent or long-term effects that the child that was the victim of this abuse is suffering?
I don't know the specifics. I've had very limited information as far as that child. I know he's had to have some additional medical stuff that he's had to endure, but I don't know the specifics of what long-term effects he would have had or is sustaining. I don't know. He's not a part of our case, so I don't have that contact with his mom. Most of mine is through the relative caregiver for this minor child.
Okay, I have another person, thank you.
Redirect.
No, Your Honor.
Thank you for your testimony. May I return to your seat? Any other witnesses? No, Your Honor. Thank you. Mr. Mawad.
Judge, I'm going to grab my first one and I'm going to go be as expeditiously as I can to get it done, because we have to try to get this matter resolved. I think it's in the best interest of everybody. Okay. Thanks, Judge. Jennifer, how are you related, or how do you know Bailey Demansky?
I'm her aunt. Okay, so she's your niece.
Yes,
All right. What do you do for a living?
I am a teacher
Where
at
at?
Light of the World Academy in Pinckney.
And what else do you, or have you done?
I am a certified teacher now. Before that, I've done childcare for 15 years, both at home and at a public daycare.
In the last, we'll say 10 years, how much interaction have you had with Bailey, first of all, with Bailey, your niece?
Not so much in the past few years since she was, I guess since my kids were older and I got really busy with sports, but before that, she would go camping with us, shopping with us. A lot of time, I would say.
Would you see Bailey with your kids also?
Yes,
And there were 2 boys?
yes.
And do you have an opinion of, well, have you ever witnessed any assaultive or worrisome conduct between Bailey and her kids?
No,
And you work for the state of Michigan and for childcare and childcare center.
yes.
How would you explain Bailey, when you've seen Bailey and her kids, how would you explain Bailey's relationship with the children?
I think she's always been very like mild mannered, very calm, both with her children and mine. Never ever seen her raise her voice or do anything that wasn't like nothing questionable, I guess.
Do you have any doubts about her love for the children at all? Or her
No.
boy for her kids?
No,
And you said she's had interactions with your kids?
yes.
Do you know how old your kids were when she had these interactions?
Their whole lives. I mean, they've always spent time with her as they were younger. She would spend a lot of time with them. They absolutely adored her. And she would babysit them later. And
I do not have any more questions.
Cross-examination?
I have no questions, Your Honor.
Go ahead. Any questions, Ms. Berger?
Thank you. Mr. Mansky, have you had contact with, mother in this case since this case opened?
this, I guess, no.
And have you, seen the photos of the injuries of the child involved in this case?
Yes,
And you would agree that those are pretty horrific?
yes,
And you are aware that, that mother admitted to causing those injuries?
yes,
And would you trust her with your children after that?
yes, I would.
Why is that?
Because I've never seen her do anything violent where I'm still questionable about that case.
Do you believe that she lied in admitting that she caused those injuries?
I don't know.
No further questions.
You agree?
None, Judge.
Okay, thank you for your testimony. Will you need this witness to remain further sequestered?
I don't know. I'll ask.
No, Your Honor.
Ms. Berger?
No, thank you.
All right, you're released, meaning you can stay if you wish or leave if you wish.
Cody, good afternoon. Are you married or single?
I'm married.
And your wife's name is?
Morgan.
You have children?
We did. She's deceased now.
Okay. Are you in the custody of any children right now?
Mason.
Just the initials? You just
Oh,
said the initials.
MW.
Okay. And how old is MW?
He is 5.
Who's the mother for MW?
Bailey.
Okay. Has MW had contact in any way, or have you allowed contact between MW and Bailey whilst Bailey's been incarcerated?
Yes.
How long has that been occurring?
I say about 2 months now.
Okay, and how's the contact been?
Been really well.
Well, I mean, has it been in person, by video?
Oh, by video.
Okay, and how long has that, how long have been the video appointments or meetings?
Some days are 30 minutes. Other days are an hour. It depends on if Mason wants to talk or not.
Does MW want to talk and see his mother?
Yeah.
Are you worried in any way that after Bailey gets out of the jail that she would harm MW in any way?
Nope.
Prior to her being charged with this case, you've seen Bailey with MW and other kids?
Yep.
Have you ever seen Bailey prior to her being charged on this case and this incident happening that she was charged with? You ever seen her lose her temper or?
No, never.
you always, what is your perception of her as a mother?
She's a great mother. She took care of Mason when we were together and after. She's great. I have no worries.
You want Bailey to continue to contact with MW?
Yes.
I don't have any more questions.
Cross-examination?
Mr. West, did you file for a change of custody as it relates to MW since the opening of this case?
Not yet.
And so what is the current custody order?
It's 50-50 right now.
And you have been at these hearings before, correct?
I have.
And you've heard testimony about why Ms. Stefanski is under the court's jurisdiction?
Yes.
And your child was in fact under the court's jurisdiction for a time, correct?
Yes.
And I believe released because it was reported that there was a custody order pending. Is that correct?
I don't believe so.
Did you speak with Ms. Young and tell her that a custody order was pending?
I don't remember because I haven't went and filed yet.
Okay. And do you recall ever speaking to myself in the hallway with your wife present, stating that you were filing that day?
I was going to, but I just haven't had the time.
And why would you file?
Why would I?
Yeah.
Because I need to. That was part of the agreement, is that I had to file for full custody.
And but your testimony today is that you have no concern about Ms. Stefanski's ability to parent your child?
No.
Okay.
No.
Thank you. I have no further questions.
Ms. Berger?
Mr. West, have you seen the photos of the injuries that were inflicted on the child in this case?
I have.
And what are your thoughts related to that?
I mean, they're injuries. I see that, but it was a mistake, you know, and I do not believe that she will never do this again, that she will never do that again. I promise you.
No further questions. Redirect?
None,
Would you like him excused?
please.
Any objections? All right, thank you.
No. I mean, that's fine.
I don't think anybody's ever asked me that before. I don't really mind, as long as we can hear you through the microphone.
And you are the grandmother to Bailey
Yes, I
Stefanski.
am.
All right, Judge, what I'm recommending, if there's no objection to make this, she wants to read a letter. Instead of me cross-examining her, then I'm not gonna ask her any more questions, then we can see if there's redirect. With permission of the court and the other party, she's gonna read a 2-page letter, probably gonna be about a minute. That's all. The court doesn't have any issues with it.
No.
No objection.
Right?
Okay, we all deserve a second chance, and our granddaughter deserves that second chance to be back with her sons, Mason and Braden, the loving mother that she is. Bailey has always provided stability and care for herself and for her boys. She has went above and beyond whatever CPS wanted her to do to get Braden and Mason back in her life. I have been with our granddaughter through the years while she interacted with her nephews and younger cousins, and she is absolutely great with them. When she was living with Aaron at the time, she was watching all 5 kids: Isabel, Liam, Jonah, Mason, and Braden. And all 5 kids at the time was 5 years and younger. And I have seen her potty training Mason, Liam, and Jonah, and they were all 3 years and younger. And at the time, she was breastfeeding Braden every 2 hours. And I saw how much patience she had with all her children that she cared for. Bailey and I have been with all 5 kids in the car, taking Mason to Brighton to be with his dad. We all had good times, singing songs, playing games, and she had all 5 kids with her, and they actually loved calling her Mama Bailey. When Bailey gave birth to Mason and Braden, she had both boys natural. for the fear of them being hurt with the drug. Bailey has always been a hard-working mother, and she has supplied clothing, diapers, etc. to Brady and Mason, and CPS took her boys away from her. And still to this day, while she is incarcerated, she is still providing for her two sons, Mason and Brady. Bailey has always had a bond with Mason and Brady. Bailey continues and still continues to support her boys, even after the courts, without notice to Bailey, stopped her visitations with the boys. It's an honor and special blessing to be grandparents. I'm one of them. But there is no greater love than to be a mother. It's a love that will never go away from a mother and her children. Grandparents might have a special bond with their grandkids, but that bond that a mother and her children has will never, ever be broken. It's a special bond that God gives to us, and no one can ever take that away. Bailey deserves a second chance. She has went beyond everything that the courts and CPS has asked her to do. So please give her that second chance so that Mason and Brady can enjoy growing up together with their mother in a loving home. Thank you.
No questions, Judge?
I have no questions, Your Honor.
No questions. Thank you for your statement. Dr. Lisa?
Yes, please, one more and then Bailey, Judge.
No.
Hi, Jenna. You know Bailey, Nancy. Can you tell the court how you know if you can speak up a little bit too?
I met Bailey early in 2020 when I was dating her younger brother.
Okay. And until she was incarcerated, did you remain in contact with her?
I did.
All right. And in that time period that you remained in contact with her, did you have occasion to see her with her kids, her two boys?
I did. We would get together often.
And when you say we get together often, was it at the house? Was it at holidays or any other occasions?
I would usually go to her house and spend time with her and the kids, or we would meet up at parks sometimes because I live a little far away. So we would meet halfway.
Where do you live?
I live in Livonia.
Okay, so you do have a little drive. Okay.
Yeah.
What are your observations of Bailey as a mother?
Ever since I met her, her kids have always been number one. When I first met her, she just had Mason, and he was always part of everything we did. And she always wanted to spend time with him. And when he was with his dad, she always expressed how much she missed him. And it's just very clear that she loves him so much.
In your observations, did you ever see her get assaulted at all or hit the children in an assaultive way?
Never.
All right, you understand why she's in jail, right?
Yes.
All right, and do you think that, in your opinion, just asking your opinion, do you think that this would ever happen again?
No.
I don't have any questions.
I have no questions, Your Honor.
None. Thank you for your testimony. Would you like to release her?
Yes.
You are released. I trust our two attorneys to let me know if they have any objections to that.
No objections.
And then my last witness is Bailey. Unmute.
You may have to push a button to unmute. The answer is that yes, you do?
Yes.
Thank you.
Hi, Bailey.
Hi,
I have some questions for you. How old are you now?
I am 26.
All right, when you got charged with this case, how old were you?
26.
26?
Yes,
When you got charged with the crime, how old were you?
26.
You're still 26, okay. And you had two children. You have two children, correct?
Yes.
Just the initials? What are their initials?
MW and BS.
Okay. Prior to being arrested, where were you living?
I was living at Aaron's residence, and then I packed all my stuff and I moved to my grandparents.
In what city or township with your grandmother?
Petersburg.
Okay, and that's, your grandmother's the one that just testified?
Yes,
And also your grandfather lives there too, right?
yes,
At that time, were you working?
yes.
Okay, where were you working?
I was working at Plastic Omnium.
Where's that located? Where's that company located?
It's in Adrian on Beecher.
Okay. Was that a full-time job?
Yes,
Were you providing for your kids with food, clothing, shelter?
I was providing clothes wise and
What about,
their basic needs.
okay, fair enough. How, prior to being arrested, how old was, M?
He was 4.
And then what about BS?
1.
After you got arrested and during the term of the CPS hearing, can you tell the court what you have done as far as services? What kind of services have you had? And then I'll get to what you're doing in the jail.
I have completed my hold on. I have completed my anger management and counseling through Catholic Charities. I have completed my physical and narrow evaluation on June 27th of 2022. I have completed my direct family assistance program, program from Orchard Family Services. I have, what else? I have complied with doing supervised visitation therapeutic and then got moved to the DHS office. And that's
Any issues with that, with the visitations at all?
no.
Any issues? Okay. During the appointments for your mental health, you were working on some issues from your past. Was that correct?
Yes.
Okay. And you were getting treated for that, for those issues?
Yes.
All right. And I know that you're going to be asked this question about the criminal matter. You obviously pled to a child abuse charge on a different minor, correct?
Yes.
And you would agree you severely hurt that child after reviewing the police reports and seeing pictures. And you understand at first you didn't tell the detective the truth. Would you agree with that?
Yes.
And then it was subsequently, I don't have the police report in front of you, but maybe a couple days later when he re-interviewed you, that you finally admitted to striking that child and hurting that child, correct?
Yeah.
All right. What accomplishments and goals have you made to make sure that this should and would not happen again regarding your mental health or anything else?
I have some resources. When I get out, I could go to counseling and anger management still. I have mental and physical support of my family and my friends. And then if I need like any further needs, then I could just research them.
If the court made a decision not to terminate but to reunify, it would be, you understand, a long reunification if the court does that. It's up to the court. You understand that, correct? And you would follow all the orders of the court and of the your workers, correct?
Yes.
And obtain all the services that you would have to obtain, correct?
Yes.
All right. What are your plans after? Well, let me start off by this. You are you get out of jail in June of this year, correct?
Yes, June 8th.
Where would you go to live?
Huh?
Where would you go to live? Where would you go?
I am going to live with my grandparents.
Okay, and the grandmother being the one that testified today in Petersburg?
Yes.
Okay, and then
What about your job? Do you think you would get your job back that you had prior to going into the jail?
I might be able to. I'm gonna contact them when I get out.
Explain to the court what you did at that facility. What was your job duties there?
I was an operator.
And how many hours did you work?
I work
For them.
40+ hours a week.
Okay, all right. And you're willing to maintain that home free of any domestic violence, substance abuse, or any other type of criminal activity? You'd be willing to do that? All right.
Yes, sir.
Would you appropriately also care for BS
Yes, sir.
and Mason at some point in time if they were to live with you?
Yes, sir.
All right. And would you, now this is the question I have to ask, with the assault that occurred on the minor child that you're charged with, do you believe that you can demonstrate the ability to have that never occur to any minor, whether it's your own children or any other children?
I would not do that.
What, anything else you want to tell the judge regarding, I know, because the judge is very familiar with your case, she's very familiar with everything that you've done, and the CPS workers has been very truthful about what's going on. Anything you want to tell the judge before I stop questioning?
Yes, I do actually. I was wondering if I could possibly get an extension so I could rebuild my bond with my son BS, and to provide a safe, loving, and caring environment.
Are you, you think you've grown up a lot since this matter, since the criminal matter? Matured more?
Yes.
You think you were a little bit more immature as far as how to handle stress with other children back then? Do you think with the help of the services you've received with the court and everything, you are definitely a different person than what you were before?
Yes, sir.
Okay. All right. I don't have any more questions at this point.
Cross-examination?
No, Your Honor.
None.
Thank you.
No.
Do you have any witnesses you wanted to present today, Ms. Berger?
No, thank you.
Before we go into closings, I'd like to take a brief recess and chat with you. Well, first I want to just thank the attorneys for our bench conference. Really enjoy the opportunity to talk with them about a few aspects of the case that many of which we've already discussed today. But I believe, I think we're going to end up with an adjournment to allow a second psychological evaluation. And I'll let them go ahead with any other comments that they might have on the sidebar, beginning with our guardian ad litem.
Yes, thank you, Your Honor. I do believe that we are requesting some additional time to have another evaluation done for mom and to explore other avenues of permanency for this child. So I do believe that we are asking for this day to be reset. We are out of time for the day as well. So before we can finish, I'm asking that we give another date and some more time to explore all the options.
Ms. Thomas?
I concur with the LJ on this matter.
I concur.
All right, very good. Our next regular review is set for February 16th, so we think that's probably a bit soon. So we'll, I think, let that one go on as scheduled and then look for some time in March. Does that give you enough time to secure psychological, or do you want a full 90 days?
Yeah, I think I hate the idea of having to extend this out another 3 months, but given, honestly, the last time we tried to schedule one, we were scheduling a month out. And by the time it's completed and then written, I don't know that we'll have it by early March. So,
Yep, that's what I was asking.
yeah. Do you have any idea where we're at this?
Well, if we do that, we are looking at, we can come back together on Monday, the 8th or Tuesday, the 9th of April.
Tuesday the 9th.
Yes, so that would be a 3:30 spot.
Okay.
Your Honor, I don't mind doing that. I just will be appearing mute.
Option B is go to the 23rd?
April?
Yes, if you'd like to be the first one.
I don't mind being on Zoom if no one else is back, if everyone's okay with that.
I don't care. I mean, whichever, 9th, 23rd, it gives us some time now to see what the report reveals and maybe talk more.
Well, let's go ahead and schedule it for the 23rd. Is there, right now you have open on the 22nd and the 23rd. Is there any preference?
I would prefer afternoon if that's okay.
I'm not available the 22nd, but I am anytime.
All right. 1:30, April 23rd?
Sure.
Oh. What we're gonna do is leave the proofs open then, and essentially conclude with another review, and any additional arguments will take place on that April 23rd date at 1:30. We will be asking the department to make that referral, and then it will be up to Mr. Mawad to secure permission and logistics around that opportunity.
I'll get on it, Judge. Thank you.
All right, it would appear that all other prior court orders will remain in full force and effect, and that would be the most appropriate. Anything else then for the record?
Nothing further.
Nothing further.
All right, thanks again. We'll see you back April 23rd at 1. Great. We are scheduled today for review, permanency planning hearing, and a hearing on a petition for request of termination of parental rights of Aaron Schmidt as to the minor child concerned in this case. May I have the names of our participants, please?
Good morning, I'm sorry, good afternoon, Ariel Berger here on behalf of the minor children as guardian ad litem.
This is Tasha Thomas, counsel for the department.
Caitlin Young, Department of Health and Human Services.
Michael Brooks, I represent Aaron Schmidt. Is Mr. Schmidt in the courtroom or online?
Have Aaron logged in. I don't see anybody else in the courtroom, but we do have an Aaron logged in.
Yes, Aaron Schmidt, representing the father.
Thank you. All right, I should say for the record, we did have a sidebar before we came on record today. Any comments on that, Ms. Berger?
I don't think so, Your Honor. We had discussed possibly adjourning this to be held with mother's trial, but I don't believe that is necessary at this time, so we're asking to move forward today.
Ms. Thomas, any comments?
I agree with LJL, thank you.
Mr. Brooks?
I guess I'm the odd man out. I don't agree. I think it's unusual to look at a termination of parental rights for one parent, not for the other, unless there's some really strange circumstances going on. So my opinion is we should adjourn this until decisions made with respect to where the department wants to go with the mother.
I would note for the record that the termination petition does indicate a request for termination of parental rights for mother and father. I'm not sure if that's been scheduled. I think it has been actually. 4/23/24 at 1:30 is when that one is scheduled. There was one issue that came up. There's a request for a second psychiatric or psychological evaluation in that one in an attempt to measure the benefits from the services that she did undertake. So just to clarify, there is a pending termination request filed for both parents.
Well, I don't think April 23rd, if that was the date, is very far off anyway. So I don't see any harm. The child, as I understand it, is living with my client's parents and has for quite some time. I don't see any immediate problem leaving status quo as it is.
Your position on the request, on the motion to adjourn, Ms. Thomas?
Your Honor, I agree with Mr. Brooks, and often we look at the permanency for the child, and termination is not permanency for the child. Adoption would be permanency for the child. Part of the issue with mom's case and asking for that second psychological evaluation is to determine whether this child could be reunified with the mother upon her release from incarceration. But as far as the department's concerned, we have put on our proofs in that hearing and are waiting for another psychological evaluation. This petition has been outstanding on both parents since September. Maybe not September. November, I'm sorry. So it's been more than 3 months, and we're well over our standard timeframe, which I think we're supposed to have these within 42 days of being filed. So I would ask that we continue on the termination petition, and if not, then at least get the review portion done.
Your position, Ms. Berger?
Yes, Your Honor, I would request that we move forward with the termination today. They were scheduled at separate times due to availability of the attorneys, not for any other reason. So normally we would have started fathers at the last time we were here when we started mothers. However, we weren't able to schedule it that way. So this child has been in care for almost his entire life. And I think that he deserves permanency as soon as possible. And I think we need to move towards that goal now as quickly as we can. And we have the docket time today, so I would suggest that we continue on with that termination trial today.
Thank you. I can appreciate your point, Mr. Brooks, but the docket for the next couple of months is extremely tight, number one. And number two, I think we're going to need the time that's been scheduled for Ms. Demansky's trial in April. I'm not convinced that we'd be able to get through both of them in a singular afternoon, which was also one of the reasons they were scheduled separately. And the petition has been pending since November 3rd, 2023. And I think it is in the interest of this child to begin to answer the question on permanency and stability. So for those reasons, I am going to deny the motion to adjourn. And we will have the termination proofs in conjunction with the review hearing that's been previously scheduled for this afternoon. Any other preliminary issues?
No, Your Honor.
No, Your Honor.
Nothing further, thank you.
All right. Ms. Berger, I look forward to your report.
Yes, thank you, Your Honor. I've been able to visit with the minor child virtually during this reporting period. In person, I believe in November or December as well. And I've been in pretty constant contact with his caregivers. He is super tall for his age. I think he's in maybe the 97th percentile for height and weight. He is growing like a weed. His speech is coming along. He's finally fully transitioned into a toddler bed. He really enjoys water activities. So playing in the sink, playing in the tub, taking a bath, all of those fun things. He really enjoys those. But he's very bonded to these caregivers, and I think he sees them as his parents. He's been placed with them since an infant, and they've been the ones providing medical care, transportation back and forth with daycare. And he unfortunately is prone to being sick. He has struggled with that, I think, a lot with being in daycare, but I think he was just sick again a couple of days ago. So that's kind of an ongoing battle that he faces. But they have the ability to stay home with him if they need to, or to go pick him up from daycare, and flexibility in the schedule with it, which I think is important. He's not seen either of his parents in quite some time. Father at one point was really doing well. He was completing services, he was engaged, he was visiting, and then all of a sudden he kind of dropped off the face of the earth and we didn't hear from him. And since then, the child has adjusted to his normal schedule being with his caregivers. He hasn't seen dad. Dad has not provided any support that I'm aware of. So at this time, I'm asking that we move towards permanency for him and that the court enter the orders for termination.
Thank you. Testimony, Ms. Thomas.
Yes, Your Honor. Ms. Young can be sworn in.
Ms. Young, come on up for a witness stand.
Ms. Young, how are you familiar with this matter?
I have been the foster care worker for this past year. So I've been working with this family for quite some time.
And today is in part of the hearing is inclusive of the review portion. Did you provide a court report for today's hearing?
I did, yes.
Okay. And in addition to the court report, are there any other documents that were circulated since your submission of the court report?
Yes, I did send out an email yesterday once I received the therapy information for Mr. Schmidt. So I sent the proof of service in that to everybody. And then today, right before I was coming over to court, Mr. Schmidt sent me a text with his signature on a key service plan. So I do have copies of that for everybody as well, including the courts.
Okay. Judge, may I ask the court and counsel if they have received the court report, the case service plan, and the counseling records?
Well, Your Honor, I have the case service plan, but it isn't signed by my client, so I will have to simply ask him if he signed it and sent it back.
That's the same one I believe I have, as well as the counseling records and the court report. Did you receive the counseling records, Mr. Brooks?
I did.
Okay.
Your Honor, if the court would be willing to receive a copy of the signature portion of the case service plan?
Well, Deputy Ames, would you swear in Mr. Schmidt for us just briefly so that Mr. Brooks could verify that, please? He's online.
Thank you. Thank you, sir.
All right, Mr. Brooks, go ahead.
Sir, have you heard the witness say that she today received a signed copy of your case service plan signed by you? Did you hear her say that?
Yes,
Is it an accurate statement?
yes, that is true.
All right. I have no further questions and I have no objection to its entry.
Any questions for Mr. Schmidt, counselors?
No.
All right, thank you. And I will receive that. Thank you.
Ms. Sang, are there any updates or modifications that need to be made to those documents to the best of your knowledge?
Just at this time, I did confirm with the therapy agency prior to coming over here, because I noted on the therapy reports that they sent me was just simply the dates of when he was seen by Mr. Webb. And then there was some notes from 2021 that was included in there, but there was no like formal diagnosis or like treatment diagnosis that they were working under. So I was able to discuss with them briefly kind of what he was being seen for. So, but it's consistent with some of his other treatment that he was receiving in prior therapy. So it was an adjusted mood disorder with depression. So that was simply what they were seeing him for up through November of this year.
Okay. And have there been any other, to the best of your knowledge, any other counseling since November?
To the best of my knowledge, no.
Okay. And so during this last review period, how would you describe Mr. Schmidt's compliance and benefit from his case service plan?
At this time, just in partial compliance. So, you know, we've had consistent communication, we've been in contact. Because of scheduling, we weren't able to do a whole lot of face-to-face contact, but we were trying to at least meet by phone or text. I've been able to send emails to him with the documents. But as far as the therapy, I am kind of concerned that he scheduled something in December and then didn't go. And there's been nothing since that November, I think either 13th or 16th, I believe is what it stated in the report. He hasn't been seen since then. So I don't know about discussing that with Mr. Schmidt as to why he wasn't completing that, but there's been nothing further beyond that. There's been no other services that he's participated to my knowledge.
It looks like reviewing the report that you provided, the last date he was seen, and based on this, it looks like December 7th, 2023. Does that seem about right?
That was a scheduled one, but he was not in attendance at that hearing. It notes on in the front of the document that a booked appointment means the appointment was made, but could not have been a no-show, and checked out means he had an appointment and that he was seen. So,
okay. So that was the last scheduled one. That's what you're referring to. He did not show.
Okay, correct.
And to the best of your knowledge, has he provided any documentation to you that he is engaged in therapy elsewhere?
No.
As it relates to like the psychological or neuropsychological evaluation, he completed that in August of 2022. Do you know if he's completed any of the recommendations?
One of the recommendations was him to follow through with the counseling, but he's been very inconsistent throughout this entire case and consistently staying with one therapist. At one point, he was seeing Crystal Strickland out of Monroe County, and he was going there very briefly, and then that's when we were looking at potential reunification. He stopped visiting, he stopped communicating for a few months, and then just re-engaged in services around June, July of 2023. And that's when he enrolled in therapy with ACPC for adjournment counseling through telehealth. He was being seen up until about November, and then there's been no further appointments since then.
As relates to his housing, in the past, it's been appropriate. Does it remain appropriate at this time?
As far as, to the best of my knowledge, yes, he's still remaining in the same residence that I last seen him at. He's out in Albion. So.
And has he provided proof of income?
Nothing recent, but we have discussed that previously, that he was still remaining at that same company. I don't have anything recent this reporting period from him showing continued proof of that income.
One of the comments that Ms. Berger made in her report indicated Mr. Schmidt has not provided for the child. Do you have any information on that point? Has he given the placement, like any financial resources or any material resources for the child?
To my knowledge, no, nothing recent. He does not have direct communication with his parents who have placement. We've just discussed that quite a bit over the last like 6 months. He feels very like, hard to explain. He's kind of hurt. He's very distraught with some of the things that happened early on in the year. There was a lot of things that were said in a family team meeting. He kind of withdrew from wanting to participate and then trying to re-engage. And at that point, he was trying to make some lifestyle changes. He moved to a different area and with his now fiance. And he wants to remain, that communication strictly through the agency at this time. So.
When is the last time that Mr. Schmidt saw his child?
I believe the last scheduled visit was March 20th of 2023. And I think that was the last one that he participated in.
And that's 11 months ago. Has he asked what he needs to do to reinstate visits at all?
We've discussed that. We actually had a meeting with his attorney to try to discuss seeing if he could request to do supervised contact and what that would look like. We also talked about engaging in therapy services and then exploring any other possible resources in his community that he felt that would be beneficial to him. At that time, he was already engaged in therapy services. He was still kind of in denial as to the situation that brought the child into care, that he had any involvement in it. He didn't feel that it was fair to him, that he was not being able to see his child or to be able to have him back in his care. So there was a lot of emotion expressed by him. And myself and Mr. Brooks at that time during that meeting were trying to explain to him these were some of the things that occurred. For that time period, there was no communication from him. You stopped visiting. We were ready to reunify with you. We had services put in place. You refused to cooperate with those services, and then you disengaged from everybody and everything related to this case. So we had that long discussion, and since then we've talked about continuing with therapy services, trying to maintain that. We understand visitation is suspended. We can't do anything about that. Alternative means to be able to communicate either through the agency, written contact, what can we do to try to at least have some sort of involvement in your son's life. But there hasn't been any written communication at all from Mr. Schmidt for his child.
And just for the record, when did you and Mr. Brooks have that conversation with Mr. Schmidt?
I don't know the exact date. I believe it was around November of 2023. It was a phone call. We did a meeting over the phone. Three-way called it to discuss some of that.
Thank you. As it relates to parenting education, though, he did complete some of those services during this case, correct?
He did. Prior to me coming onto the case, he had just finished up a program through Ocurrs. And I believe it was about a 6-month, pretty in-depth parenting education program. Once he completed that, that was at that point we were looking at FRP services to reunify. It was just a matter of basically switching programs to their organization, but there was no communication or very little communication between him and the workers. They would set up dates to work with him, and he wouldn't be there, or he wouldn't communicate, hey, I have something came up, I'm not going to be home. So they would show up, and it would be a no call, no show, unfortunately. But so he has completed some. Is there benefit? I can't say yes or no, because with the inconsistency since completing that program, it's really hard to say what kind of benefit that he did show from that.
And at this time, do you think that there would be a substantial risk of harm to the child's life or mental well-being if the court were to reunify the child with Mr. Schmidt today?
At this time, yes.
And can you just briefly elaborate what that risk of harm would be?
At this time, because he has not had a consistent contact with his child since, for about 11 months, this child is not familiar with that structure no longer. Like, he doesn't have that parenting time with him on a weekly basis. He's not able to familiarize himself with Mr. Schmidt. So at this time, it would be a matter of he would need to be reintegrated with him in a supervised setting moving forward if that were to be the case. This child has been in care, as Ms. Berger had stated, almost his entire life. And we are here almost a little over 2 years into this case, and this child has not seen his dad for 11 months of that time. So at this time, it would be a risk of harm to return him.
The conditions that brought the child into care came from another a half sibling of this child being physically abused, but Mr. Schmidt was not the alleged abuser in that case, correct?
He was a household member, but not the perpetrator, from my understanding. He was not the one that inflicted the injuries.
And so part of the concern was, I guess, his parenting ability. Is that correct?
Yes.
And you stated that when you had this conversation regarding parenting time or what can happen to get that reinstated, he still wasn't understanding his role in that. Is that accurate?
That is accurate, yes.
Okay. As relates to the barriers to reunification, are there any other barriers that are in place other than the lack of bond, and sort of maybe this lack of insight as to why the child is in care?
A lot of it is inconsistency in his services. So the inconsistency in addressing the outline concerns that was in the psychological, the inconsistency not only with not being able to have contact, he, you know, for a time frame, he wouldn't even communicate with the agency. So there was a lot of concerns with his ability to be able to effectively communicate, his ability to be functioning through high stress situations. I mean, that was a very stressful time, and he disengaged. So at this time, some of those barriers really fall along the lines of the outline concerns and that psychological, with the depression, the anxiety, and social withdrawing, which is all very consistent in his lack of participation in the various services and continued attempts to be reunified.
One of the indications, or one of the notes in the psychological evaluation by Dr. Haugen indicates that Mr. Schmidt is at risk for further child abuse and neglectful tendencies, but that could be potentially due to a TBI dating back to 2014. Do you know if he's engaged in any services to address the TBI and how to, I guess, manage life while suffering from a traumatic brain injury?
Reading back into it and kind of taking a look at one that happened, because that happened about 10 years ago. He did seek treatment. It was inpatient treatment, from my understanding. It was very intensive, and it helped to essentially retrain his brain so that way he would be able to function in more of these like high stressor situations, and be able to really be really independent and everything back in the community, because it was, a traumatic brain injury. So with that, you know, his impulse control was affected. His ability really to be an effective parent full time was highly affected, and showing in his inconsistency in all of these areas, with his service providers, with the communication with the department, with communication with the courts, his parents, and so forth. He also doesn't have, from my understanding, little to no contact with his other children, with his first wife, one of which was the child that was sustained the injury. So, you know, there's been a lot of the impulse decisions. You know, he up and left his place here in this county and moved to another county with someone who he was just learning to get to know. He's now since engaged. We were just informed today before the hearing too that he also has another child on the way. So, you know, there's a lot of concerns, a lot of barriers, a lot of inconsistencies with that falls along the lines that stems from, we believe, from this traumatic brain injury.
In part of my question, we moved to best interest factors for the child. I think it's been stated a few times today that this child has been in care for nearly his entire life. Is that accurate?
That is accurate, yes.
Child's now 2.5.
He will be 3 in March.
Okay. Maybe we have his birthday wrong on here then. Okay.
But he would be turning 3 this year.
Okay. So he was removed, if his birthday's in August, so he was removed when he was about 6 months old?
Correct.
Okay. And since then, he's been in one home since that removal, correct?
That is correct.
And out of the last 2 years, he hasn't seen Mr. Schmidt in one?
Approximately.
How would you describe that bond between the child and Mr. Schmidt?
Currently, I mean, I don't believe that there would be an effective bond. He hasn't seen him in 11 months. I mean, I think prior to not seeing him, I think their bond was, you know, he had a good bond with him. He was doing unsupervised visits. He had, you know, that decent time with Mr. Schmidt. They had a good relationship with placement. And then once that contact severed. I mean, he has not seen or heard or had any involvement with his son. So there, at this time, there wouldn't be that parent-child bond that we'd be assessing.
Since the child has been in care, has all his needs been met?
They have, yes.
And has this child thrived with stability since not having parenting time with his parents?
He has been thriving where he's at.
Prior to that, and I don't know if you're the caseworker then, but when he was having parenting time with his parents, were there any concerns about his behaviors after or before parenting time?
Not that I can recall. There was a couple of months after I took over the case where there were still consistent parenting times. I don't recall really any negative behaviors that the child was exhibiting.
Okay. Does the foster, or I'm sorry, the relative placement, do they support sibling visits with the child? The child has half siblings from both mom and dad, correct?
Yes.
And do they offer support in trying to engage with those other siblings?
They do, yes.
And will the current relative placements provide permanency through adoption if this child's ever freed for adoption?
Yes, they would.
And one of the things the court must consider is that the fact that this is a relative placement and this is a paternal relative placement. And do you have an opinion as to why that does not weigh against termination in this case?
Well, at this time, I mean, in speaking with a relative, their wishes are to be able to adopt, to be able to provide that permanency and stability that they would not necessarily be able to provide to him in any other permanency plan. He's still pretty young to do like a guardianship. If they were to reunify, I mean, it would be a significant amount of time before reunification would even be able to be considered due to the lapse in time that the child has not been able to engage in any parenting time with either parent. So at this time, my opinion would be that he would need to have that permanency, and with him being in care for almost his entire life, this is the only home that he's really known and he's used to and bonded with.
And even though this is the paternal relative, earlier in testimony you stated that there's right now not a good relationship between Mr. Schmidt and his parents, correct?
That is correct.
And they're not communicating?
To the best of my knowledge, no, they're not in any communication.
So Mr. Schmidt doesn't have the opportunity or doesn't take advantage of any of these special arrangements that could exist, such as coming over for Sunday dinners, celebrating holidays together, any of those things?
No, not at this time.
Okay. Is there anything else that you'd like the court to know or consider today as it makes its findings for the review hearing, permanency planning, or for the termination?
I think just a couple of things that I've noted from my home visits with the minor child. I've had some discussion with the placement about some different situations that they've been in with the minor child. There was one incident where, I mean, as Ms. Berger stated, he loves water. He had finished dinner, got in the bath, getting ready for bed, and he ended up choking on water. And it was a very stressful, high intense situation where paramedics had to be called in. CPR was being done because he wasn't breathing. So, you know, it's hard to say like how either of the parents would handle that situation. The parents, the grandparents, and speaking to them, I mean, they worked together as a team. They were able to, you know, one was on the phone with paramedics to make sure that, you know, they were doing the proper steps as far as the CPR. The other parent, grandparent was in there performing the CPR, making sure that his airway was being cleared and he was back breathing, making sure that he was all right. And then there was another incident shortly after that where he was down for a nap, I believe. And with him being in his toddler bed, he has a little bit more free reign in his room. He had woken up, had soiled his diaper or feces and spread it everywhere. You know, so another, you know, highly stressful situation where there was literally feces all over the room, including all up and down his arms, his body. Thankfully, you know, the bathroom is right next to his bedroom, so they're able to, you know, put him right in the bathtub, get him cleaned up. But again, like I said, this is another very stressful situation. It's hard to say how Mr. Schmidt or Ms. Demansky would have handled that. You know, with it being as severe as either one of those things were. I mean, there was a lot of cleaning up, a lot of, you know, scrubbing carpets, cleaning up the beds, the walls, the blankets, the pillows, stuffed animals, everything, you know, everything needed to be done as quickly as possible because of the smell. You know, so it's really hard to say how either one of them would have handled that situation, especially with that being that highly stressful situation. So, but like I said, I did commend the foster parents on how they handled that. They, you know, they were a very good team working together in handling not just that, but also other like really good situations with this child. And, you know, he's very loved, he's very cared for. He doesn't have a need that goes unmet by far. They are a licensed foster parent, so they are aware of the protocol with, you know, any type of discipline, you know, how to maintain their home as far as licensing standards. So, you know, they're very well equipped to handling these situations, and have a very good support through not only our agency, but also the agency that they're licensed through. At one point, they did have a very good line of communication with Mr. Schmidt. And then at one point, they, you know, following a meeting and some allegations, it just, that line of communication was severed at that point. So, you know, at this time, we asked that we can move forward and continue with this process towards adoption.
Thank you. I have no further questions. No to admit the court report with the attachments. Thank you.
Objections, Mr. Brooks?
No, Your Honor. No objection.
Thank you. The court report and the medical records are received, as well as the case services plan. Questions for this witness, Mr. Brooks?
You mentioned that, let me find it here. He doesn't understand his role in the abuse of this child. Was that your testimony?
I think there is some question in his ability to understand that. I mean, there's times where he gets very frustrated and doesn't understand as to why the child was brought into care or why he's not able to have the child in his care. So yes, there is some question as far as his ability to understand the severity of why we are here today.
But he really didn't have any role in the incident, did he?
I couldn't say for sure. I mean, there was some inconsistency as to that CPS investigation when they were interviewing both parties, and then the minor children that were able to have an assessment. So I don't know if he necessarily was a part of physically abusing that minor child, but he has a role as a household member, an adult, a parent to that minor child that was injured.
Well, at the time it occurred, isn't it? According to police reports, he was at work, wasn't he?
From my understanding, yes. I think the follow-up following when he got home from work, and you know, when the child was observed at school the next day, there was some question as to why, you know, he was not observing that child himself before that child went to school. So there is some question in regards to that, and so I think he has a role in it, but not to the extent mom did.
Okay. When was the last time you had contact with his son?
March 20th of 2023 was the last scheduled parenting time that he had with the minor child.
And we're here on March 16th, 2024, right?
February.
Oh, I'm sorry, February 16th. So 11 months.
Correct.
And his father was a strong supporter of his early on in this case, was he not?
His stepdad and mom, they were both very supportive, and they have been this entire time. But I'm that middle person in the communication between Mr. Schmidt and his parents at this time.
So something has changed in that relationship, right?
Correct.
Do you know what?
Well, we had a family team meeting a while back, I want to say it was around that March 20th timeframe. While we were in that family team meeting, I mean, there was a lot of concerns that were expressed by not only our agency, but also his parents, some things that, you know, really fall under the lines of concerns being unsupervised with a minor child. There were some reports that he was being around some individuals who were not really safe for not only Aaron to be around, but also my child to be around. So there were some safety factors, and we have police reports that supported that, that safety factor. There were also, you know, and I don't know exactly what else was said between them following that meeting, but I know there was just, you know, a lot of emotions kind of that followed that. I mean, Mr. Schmidt didn't really agree with everything that was being said, and he just felt like he was being attacked and that he wasn't being supported in that moment. We were trying to be as supportive as we could, trying to kind of get to the bottom of what the concerns were. And at that point, we were recommending to try to do some supervised visits again. So that way we can look into things further, if there were continued safety factors, we wanted to address that and make sure, the minor child was not put into an unsafe situation in an unsupervised setting. So, we're taking a look at it, covering all grounds at that point.
Now, you've indicated that basically he has been a no-show for the better part of a year. Is that an accurate summary of what you said?
Not necessarily a no-show for everything. He has had a lot of inconsistencies. I wouldn't say necessarily a no-show. There were some inconsistency as far as his therapies previous to where he's at now, where they would have, some sessions sporadically and then, no communication for a significant amount of time, where he then was discharged from that service. The same thing was for FRP back early of this last year. He would set up appointments and then he wouldn't be there for those set appointments. So, again, that inconsistency of any form of communication. And then, he just stopped communicating with anybody for about 2 months approximately. So when he started therapy back up, he was consistent for a short time, missed, and I don't know the extent of why a visit or the therapy session was canceled, but then he had a few more sessions and then no more since then. So, there is concern with that inconsistency, yes.
Where does he live? And I don't mean the address, but what town?
He's currently in Albion, Michigan, from my understanding.
Albion. Has he expressed to you any issues with transportation to get to his various and sundry programs?
No, his therapy sessions are telehealth, so it's all virtual. It's not a face-to-face session.
Do you know if he has a computer or a phone that would allow him to take advantage of that?
Yes,
He does have that.
he does, yes.
When did the court suspend all visitation with the boy and his father? Do you
I
recall?
think a motion was filed around, I think, May 26th or 27th of 2023.
So from essentially June 1st on, he's been prohibited to visit with his son. Is that right?
That's correct, yes.
So for 6 or 7 of those 11 months, he just flat out not been allowed to see his child. Is that right?
Per a motion, yes, but we discussed steps that he could take to show that he wanted to be involved in a child's life. And he tried to do some therapy sessions, but that was the extent of his participation in anything in regards to that reunification process.
I have no further questions. Thank you.
Ms. Berger, any questions? No, Your Honor. Thank you for your testimony. Well, maybe I should check with Ms. Thomas on redirect.
I have none, thank you.
All right, thank you for your testimony. We are returning your seat. Other witness testimony today, Ms. Thomas?
No, Your Honor.
Mr. Brooks?
Mr. Schmidt, would you like to testify?
No.
Pardon me?
Yeah.
Okay. You've heard the testimony of the worker, Caitlin Young, have you not?
Yes.
All right. Is there anything she said you disagree with?
I disagree for the fact that I have been trying to find ways to move forward into my absence when I left flat I left flat from the earth or disappeared for months, and I've been asking questions to the case service, Caitlin. What do I do? What am I up?
Okay, you're really coming in and out. I'm not getting maybe even every other word on this end. So
I'm sorry.
I'm not sure. Maybe you could try to move in closer to the microphone and try again.
Okay, is this better?
It is, yeah.
Sorry about that. So when I disappeared in those few months, and then I tried to come back and move forward, I have tried to and been engaged more by asking Caitlin, my case service worker, what do I need to do to move forward in this, and to do better for Braden, to show that I am more motivated for Braden, and to just do the best that I can for him. And at the time, the only thing I had to complete was my counseling. So I've been doing that ever since, trying to show more effort to showing what I need to engage in since then.
What is the counseling you've been engaged in?
So his name is Nate Webb, and we talk about my emotions and how to handle them. Talking about how things are going in life, how I'm handling my situation with Braden, where do I need to go and get him back, and talk about everything.
How often do you see this counselor?
About once a week, once a month.
What big difference between once a week and once a month? Which is it?
So it's normally once a week, and then he had getting married this month, so we waited out. But it's normally once a week. The normal is once a week.
And how often or how long has that been going on?
It's been going on since November.
Of 23?
Yes, sir.
Is he someone local over where you live, or is he on online counseling?
He's from Adrian, but we do online telegraph.
Okay. Are there any other things that you're doing to benefit yourself in this matter?
Just
Well, let me help you out. Are you working?
yes.
Where do you work?
So I work at Denzel Manufacturing. I've been there for almost a year.
All right. What are your hours there?
I work about 70 hours a week.
70?
Yep.
Wow. Okay. Have you contributed anything financially for your son's care?
I have not.
Can you tell us why?
I have not been able to engage with him.
Well, he's only 3, right?
Yes, sir.
Have you been able to engage with his caregivers? I understand that is your mother and her husband. Is that right?
Yes, sir. And we have not engaged or talked.
What's the problem?
I just have some personal issues with them. I just didn't agree with, so we just moved forward and haven't talked to him since.
Well, you do understand that in order to have a relationship presently with your son, you have to go through the DHHS and his caregivers, right?
Yes, sir. And I would treat that with respect and just be mature about things and not. If I was ever to have visitation with my son, me and my mom have nothing to do with Braden. With our personal issues, it's all about Braden, take care of him, and getting along with my mom for Braden at that point, or along with my stepdad at that point. My personal issues will not affect with co-parenting or anything personal with Braden.
Okay. Have you made attempts to reintroduce or begin having contact again? Have you tried to get something done about this court order?
Yes, sir.
What have you done?
I've been talking to Caitlin, my case service plan, to see what I need to do to move forward and to move forward into the reunification with my son. And
I'm sorry, I didn't mean to interrupt. Go ahead.
And so doing these plans was the option at that point.
When's the last time you made an attempt like that?
I want to say when we had that meeting, me and you, to move forward. And ever since, I've been doing my counseling and engaging into my plans as I need to and be more motivated as a father.
Okay. If there were other things in that case service plan to do, are you willing to do them?
Yes, sir.
Probably on these telehealth programs, right?
Yes, sir.
Are you taking any medications at this point in time?
No, sir.
Are you supposed to be?
No, sir.
They mentioned you have a traumatic brain injury. Are you aware of that?
Yes, sir. That happened when I was 19.
How old are you now?
I'm 29.
10 years ago. Are you aware of what limitations, if any, that injury is causing you?
Yes, sir.
What are they?
My emotions. So I've learned from when I went to rehab for a year in the beginning of my accident how to control my emotions and how to all these skills of emotions and how to handle things more properly. And then also, while through these services, also in my parenting classes, they have taught me to find different ways into um, being more engaged with Braden and being more how to do things more appropriate and be more teach him the skills that he needs to learn through my parenting classes and counseling and looking for guidance. So recognizing when I need to do something for Braden or when he does something bad or seems bad at his age to understand that, the appropriate of what he knows at his age and knowing how to discipline and knowing how to teach him right and wrong.
Well, you have not personally been involved or even accused of, how would I put this, any inappropriate corporal punishment of your son, have you?
No, sir.
What would you like to see the court do here today?
To move forward and if a possibility to have reunification with my son. I know it's a lot to ask, but I think I owe it to him to show that he still needs a father. And I think that it would be best for him in the long term, to know more of me, to be more comfortable with me, and to just know me.
Is there anything else you'd like to tell the court?
No, sir.
Thank you. I have no further questions.
Cross-examination, Ms. Thomas?
Just a couple of questions. Mr. Schmidt, can you hear me okay?
Yes.
Mr. Schmidt, you mentioned that you have been in therapy since November with Mr. Webb.
Yes.
The medical reports that we have indicate that therapy started back in July.
So it started in July, and then he had some things going on, and so we had to reschedule. And so I've been attending to my appointments. I went back to November with him after his vacation and stuff like that.
These reports indicate that you had essentially monthly, bi-weekly appointments with him. And then your last one was scheduled for December 7th and you haven't been back. Is that accurate?
That is accurate.
So he's been on vacation for 2 months?
Yes.
In your parenting classes that you just testified about, what you learned, did you learn anything about what it might be like for a 2 or 3-year-old to not see a parent for a year at a time?
So in my parenting classes, they've taught me to, I've asked questions about, it's been a while since I see my other kids. So I would like to know how to get them more comfortable with me, because it's been a while since I've seen them too. And unfortunately, I'm not able to see them until this case is closed. It's been a long and rough process, but we've talked about also in my counseling, how to deal with getting them to be more comfortable in seeing me and to my environment. So I've talked to counselors on how to, and my parenting class teachers on how to properly be reunified with my kids when I see them again, because it's going to be hard. There's going to be a lot of crying. There's going to be a lot of emotions. So To answer your question, yes, I have.
So what might it be like for a 3-year-old to be reintroduced to you who hasn't seen you in a year?
So there's gonna be a lot of not being used to me. He's not gonna know me. He's not gonna see me as his dad. He's gonna be more towards my mom, my dad, because that's what he's more comfortable with. But from what I've been taught and for the techniques I've learned, just to let him know that he is safe and secure with me, and just to let him know like he can be in a loving, warmth environment here too. Just to let him know like things will be okay, and to work with him and be patient with him, and just to keep working towards our relationship or building one.
Do you think it's fair for your child to wait 2 years for you to be ready to parent him?
I don't think it's fair for anybody to go through the time that we've missed and the years that we've missed. So no, I don't think it's fair for anybody.
No further questions, Your Honor.
Ms. Berger?
No questions.
All right. Anyone else you'd like us to hear from, Mr. Brooks?
No, Your Honor.
Ms. Berger, any witnesses today?
Not today.
Very well. Argument, Ms. Thomas.
Thank you, Your Honor. As relates to the review hearing, we ask that this court find reasonable efforts towards reunification continue to be made despite the goal being adoption, but we also ask the court to find reasonable efforts towards adoption were being made during this review period as well. We are not asking for another review period because we are asking this court to determine adoption remains the best permanency goal for this child, and that termination of parental rights is appropriate at this time. Although I did not plead in the petition, I would ask this court to consider termination under statutory grounds of MCL 712A.19B3, subparagraph A2, which is that the parent has deserted the child for 91 or more days and has failed to seek custody of the child. And I think that's pretty clear in this case that we've had a father who had disappeared for a while. Parenting time was suspended. He did not try to engage in anything to object to that order to suspend parenting time. He didn't avail himself of services. This court has the record from the last 2 years about how inconsistent he has been, and really how this last year derailed that progress. And I think that speaks to subsection C1 or CI, that Mr. Schmidt has been a respondent for more than 182 days, has been a respondent, and it's been more than 182 days since he was entered into his initial dispositional order, and that the conditions that led to adjudication continue to exist, which were the failure to protect and improper supervision. Again, today we're hearing testimony that he didn't have any, or this idea that he didn't have anything to do with the child's half-brother's physical abuse, but the real condition there was the failure to safely parent. And to this day, we still don't have any proof that he can do that. And actually kind of the status quo that he hasn't, despite being engaged in services early on, hasn't demonstrated any benefit from them in the last year. And that's not the caseworker's fault or anyone else's fault other than the parent who has the responsibility to engage in services and show benefit from them. Given that this child has been in care for 2 years, I don't think it's appropriate to ask the child to wait another year for there to be sufficient compliance with the case service plan to show benefit from it and then to be reintroduced to this individual. I also think that there's clear convincing evidence under subsection J, the reasonable likelihood based on the conduct or capacity of the child's parent, Mr. Schmidt, that the child would be harmed if returned to him. We heard today how, I guess we were reminded of the inconsistency that Mr. Schmidt has had throughout this case, how this child is thriving with his relative placement. This child has been pretty sickly throughout this case, as we all are aware. In the relative placement, they've done what they've needed to do to safeguard this child and make him healthy. One of the things that we enjoy hearing is how well he's developing, how big he's growing and how fast he's growing. So for those reasons, I believe that there are grounds, at least one ground, under the statute to terminate Mr. Schmidt's parental rights, and also that it is in the child's best interest to do so. This court must find by preponderance of the evidence, for the record as a whole, that is the case. And I think that this court is very aware of the facts of this case. And I'm not going to belabor the point, other than just to note that although this is a relative placement, the parent has not been able to benefit from that relationship. We've heard that there's been a breakdown in that in the last year. They don't communicate. Mr. Schmidt now claims that he could co-parent with them, but he's had a whole year to attempt to demonstrate that and has failed to do so. This child deserves permanency and stability. Given his young age, he is in a home that is willing to provide him that permanency. It meets his needs. They give him age-appropriate activities. They're able to respond to stressful situations without becoming derailed, without detaching from the world around them. And they encourage that relationship between him and his other half-siblings. So I believe for those reasons, it would be in the child's best interest to terminate Mr. Schmidt's parental rights. At this time, I know that there's the question about whether guardianship would be appropriate, given the progress that the mother made in this matter. But that question remains unanswered at this time, as we're still waiting for the proof on that. And despite that, we would ask the court to still move forward with the termination so that this child can experience permanency one way or another and be safeguarded from any further harm that a relationship with Mr. Schmidt might cause. Thank you.
Mr. Brooks?
I find it hard to understand how the DHHS can say that terminating my client's parental rights furthers their cause of creating permanency for this boy, when at the same time they say they're not at all sure that they're going to try to terminate the parental rights of the mother whose actions brought us to this case initially. And now maybe we still got to decide whether there should be a guardianship there. It's convenient for them to say my client has a role because he should have followed up in a different manner, and maybe they're right. But I think it's a little strong to say he played a role in the abuse of this child. My client has a TBI. Everybody agrees with that, including my client. And I think once the court issued its order, I don't know, in June, I guess, of last year, saying he was prohibited from visiting with his child because he wasn't visiting regularly. I think at that point, I think the DHHS gave up any pretense of making reasonable efforts to reunite this child with his dad. Now, ordinarily, absent the issue of this diagnosis of his brain injury, I would have very little sympathy with the parent. Given whatever the heck is going on in his head, I think some slack should still be given to him to get reacquainted with his son and see if perhaps something can be done to get them back on the same track. Why? Because I don't know what his limitations are. Maybe his limitations are such that he can't. But I think the trigger was pulled on this man pretty darn quick. And I really don't think they have made reasonable, they being the DHHS, has made the reasonable efforts to reunite this man with his son. And I'm still concerned about the fact they say my client played a role in injuring this boy when clearly he didn't. He had no role other than his mental limitations, which I think is a rather strongly phrased idea of what his role in this was. And I think you should allow him. And the other thing is, you may, or the court may or may not, depending on what's advocated by DHHS later down the road, not even terminate the mother. May just grant a guardianship, when in fact it was her behavior which generated this whole thing in the first place. She pled guilty. to, I think, second-degree child abuse. Nobody even charged my client with that. Nobody ever accused him of anything like that. Yet they're still considering maybe letting a guardianship be put into place. So I fail to see, one, how there's any, by terminating my client's parental rights, how it can be said that they are advancing the goal of permanency for the boy. They are not. Two, when they say they've used reasonable efforts to re-engage my client, given his limitations, they have not. And for those two reasons, I'm asking the court to deny the motion for termination.
Thank you for your comments. Ms. Berger?
Yes, thank you, Your Honor. I think it's been testified to pretty clearly today that there doesn't exist a bond between this child and his father at this point. It's been almost a year since they've had any communication or any contact, and that's solely the father's choice, decision, and fault. He was thoroughly engaged. He was actively engaged. I think that at one point I might have recommended reunification. We were getting ready to start reunification FRP classes. And at that point, father, for some reason, just kind of dropped off the face of the earth. And I don't think the agency is pulling this case too soon. I think we're almost timed out, actually. This father has had so much time to complete services, and he did complete a lot of services, but he was unable to maintain stability throughout this case. He completed what he needed to complete, got up to the point of reunification, fell through, and then couldn't fully engage again to the level in which he was previously at all for the last year almost. This child is young. He does need stability. He's been enjoying that for the last several months in the sole care of his caregivers. Whether or not mom's rights are terminated, I don't think have any bearing on if the statutory criteria have been met in this case, and I think they have. I do think that it's in the child's best interest and that it does support termination of this parent's rights. Obviously, this child is quite young and can't express his wishes, but from how he acts and how his behaviors have changed since he hasn't had any visits with any of his parents, I would say that he also is in support of this. There's a very high likelihood that he's adopted. His current placement are licensed foster home already, so we don't even have to wait for licensing to go through. And they facilitate things like extended family visits, sibling visitation. They've been able to arrange birthday parties and all sorts of things where they invite extended family, where they make sure that this child's siblings still get to be involved in his life and he and theirs. So I think that he's in the best place for him. He's being cared for by the best people to do so, and that the petition should be granted.
Thank you. The court finds that all interested parties were given notice for the purposes of today's termination hearing. I do find that reasonable efforts towards the goal of adoption have been made with the secondary goal of reunification by our caseworker, as well as Ms. Berger, in satisfaction of her obligations. Thank you. Thank you. For further purposes of the review, I would note that the secondary goal of the reunification between this child and a parent, there are efforts that were demonstrated towards that secondary goal as well. There was a lot of conversation today about a meeting that was held with Caitlin and Mr. Brooks and Mr. Schmidt in November, and we never nailed down exactly when that happened. But given that the termination petition was November 3rd, 2023, my guess would be that it would be sometime after that if it happened in November. That seemed to be the onus for Mr. Schmidt to re-engage in some counseling services, but by December 3rd, he had abandoned those efforts, as well as any efforts to reconnect really with the department or his child. And those really are the only efforts that we've seen from him since he had a very significant incident happen in February of 2023. So I cannot find that any efforts were made by, or any real efforts that would result in progress were made by Mr. Schmidt in the areas that constitute high risk in this case in the last review period. And that is very consistent with what we've seen since March of 2023 from Mr. Schmidt. So for purposes of the review, the department has certainly satisfied their obligations, and the permanency planning goal of adoption, it continues to be accurate. Ms. Domansky remains incarcerated. She's not present for purposes of today's review hearing, but it's clear from the court report that nothing has really changed on that front. We just had a very recent review that encompassed looking at her progress as well. So entering the review order from today has no detrimental effect on her case as well. She's going to be in a holding pattern until we get back, the exception of hopefully being able to access that psychological evaluation. So I will issue that review order documenting those pieces. And as I look at that evidence also, or the evidence that came out today and the case as a whole for purposes of termination, I of course have a couple of statutes to evaluate on this point. A termination of parental rights hearing is really, the court has to make findings in two phases. The first is to determine whether there's clear and convincing evidence to support statutory grounds for termination of parental rights. The second is to determine if it is in the child's best interest to terminate those parental rights. The department has asked the court to evaluate the case under 712A.19B3A II, in addition to evaluation under 3CI. And I do find that that's appropriate. I also think that the evaluation under subsection J is also relevant. So I will have it, well, actually also G and J, frankly, all apply in this particular case. And I'll go through those one by one, but I do think that there's clear and convincing evidence in this case that there has been a violation of this statute to justify termination of the parental rights of Mr. Schmidt. Beginning in order that the statute asks me to look at them, 712A.19B3A II asks the court to determine whether or not this child has been abandoned for a period of 91 days or more. Let me grab the actual language. We are. Child has been deserted under either of the following circumstances. II indicates the child's parent has deserted the child for 91 or more days and has not sought custody of the child during that period. Back in February of 2023, it appears, and we have documentation of this through the subsequent documentation in the court reports, that a very serious incident happened involving Mr. Schmidt. At the hearing in January was when high hopes were up. We had just named officially Mr. Schmidt the legal father of the child in January. He was fully engaged at the February hearing, making his way through services, as Ms. Berger referenced, but then it would appear in February, which triggered, by the way, some testimony about this from the grandparent of the child to come forward. But it looks like what happened was there was a very serious car accident where Mr. Schmidt was intoxicated. He had relapsed using maybe some substances. This is what we knew at the time based on the testimony that we had from the grandfather, and that he had lost touch with the department as well in February. So by April, we have a demonstration that Mr. Schmidt was less engaged than more engaged, even in the very first review period, even though he had made exemplary progress immediately in his services. Looked on track for reunification. That particular incident happened. He did not join us for the April hearing, and the court did suspend his parental rights based on the allegations of how dangerous that had been at that time. In the next review hearing, in July of 2023, Mr. Schmidt had remained disengaged. We didn't really talk about him much other than to say that he had not been engaged and had not been in communication with the department. And at that point alone, we were nearly at 91 days of abandonment. The court had not suspended his parenting time during that particular review hearing. I just looked at the orders to make sure of that, but rather issued a recommendation that a counselor should weigh in on any parenting time that was issued for Mr. Schmidt, which didn't matter because he wasn't asking for it. The question the statute asks is whether or not he has abandoned the child, not whether or not the department has abandoned the parent. And despite Ms. Young's efforts to reengage Mr. Schmidt, he remained at that point in time, which is at least 5 months at that point, disengaged in all respects, including parenting time and visitation for his child by his own decision, not just simply because the court had issued that order suspending his visitation in April. And then, of course, you have the opportunity for him to request that counselor and visitation between July and September, which was our next review period. Again, he remained largely unaccounted for, off the radar, etc. In September 5th, 2023, oh, you know what, I do want to visit this. He did appear at that July 18th, 2023 hearing. I do recall this actually, and he testified that he had denied that he had been intoxicated during the car accident, causing the court to raise some pretty significant questions about that. And then in September, part of the exhibits that were received into the record was the 2/24/23 Blissfield Police Report, documenting that unfortunately what Mr. Schmidt had tried to say happened at the last review hearing was incredible. The testimony of the grandfather from the initial hearing and combined with review of the police report does substantiate that in that February incident, Aaron Schmidt was found to be highly intoxicated during police contact around the car accident and a car theft. So he had maintained appropriate housing through there. His last visit was March 20th, 2023, wherein he had made comments indicating he was stepping away, didn't wish to hear from the caseworker. And by his own testimony today, he confirmed that he had been significantly absent from his child's life. So I think with all of those pieces of information, we do have clear and convincing evidence by his own testimony given today that he had abandoned the child for a period of 91 days or more, making termination appropriate under MCL 712A.19B3A subsection II. The next subsection, or the next section to consider would be the 3CII. That specific language asks the court to review whether or not a parent was a respondent in a proceeding brought under the chapter, which he was, whether or not 182 or more days have elapsed since the issuance of the initial dispositional order, and the court, by clear and convincing evidence, finds that the conditions that led to the adjudication continue to exist, and there is no reasonable likelihood that the conditions would be rectified within a reasonable time considering the child's age. This is the one where Mr. Brooks's comments are very salient. However, as I look at the case, I see a situation at the outset wherein Mr. Schmidt was heavily reliant on Bailey Demansky, arguably to the point that he was not very involved in the child care at all, which perhaps was a contributing factor. She, of course, did plead guilty to child abuse at that time. In subsequent hearings, she shared with us, as part of her rehabilitation efforts, how stressful it was to care for the high number of children that were in the home at that time. We heard then about how many hours Mr. Schmidt worked, as we did here today. So arguably, Mr. Schmidt's most involved time was the month or two during which he was engaged in services. And when I say involved, I mean arguably involved in his child's life whatsoever. It would appear from my perspective, frankly, that he's not been very well engaged as a parent before or since adjudication, with the exception of that short time frame during which we all, frankly, had high hopes that he would remain engaged and be able to be an appropriate and safe parent for his child. So that aspect of the neglect, as well as the need for counseling to understand how that could impact a child, how the abuse impacted the child, how to avoid dynamics like that in the future, were all part of the case services plan that were designed for Mr. Schmidt. He did engage in services around those, but then with his significant incident in February and subsequent complete disengagement from services, with the exception that I've explored today around some counseling that happened in November, certainly we do have a demonstration that there was no benefit from those services, and that the issues that were identified at the outset of this case remain barriers for Mr. Schmidt. There's no reasonable likelihood that those could be rectified within a reasonable time considering the child's age, regardless of the suspension of parental rights that was reflected in orders arguably from September onward. And that's because we've heard Ms. Caitlin Young testify more than once about her efforts to try to reach out and engage Mr. Schmidt and his declination to do so. There's no reason to think that that would change in the future, frankly. Even after a meeting with Mr. Brooks and Ms. Young in November, he has continued to avoid any additional services for the most part, and has not sought a way forward on visitation. So I think there's clear and convincing evidence under that particular section as well. Under subsection G, the court looks at whether or not the parent, although in the court's discretion, financially able to do so, fails to provide proper care or custody for the child. And there's no reasonable expectation that the parent would be able to provide proper care and custody within a reasonable time considering the child's age. Part of this, I always look at housing, which he has maintained appropriate housing to the best of the information that we've had during the reviews that we've been able to see that. as well as employment, if not constant, then at least significant at times, including today. Despite that 80-hour work week and the significant amount of hours he was working at the outset of the case, I've never heard any testimony, including up until today, that he has provided financially for his child. And he certainly has demonstrated quite concretely that he does have the financial ability to do that. He explained today that that was because he wasn't allowed to see his son, as if the child simply didn't exist if he wasn't there to see him. Unfortunately, that's not how that works. His child has needs on a daily basis that are being met right now by his parents, the relative placement, as well as the department. So I think there's clear and convincing evidence under this provision as well. And he's demonstrated over the course of these proceedings that he's not going to provide financially. And I find that that supports further that there's no reasonable expectation that he would be able to provide proper care and custody or support within a reasonable time, considering the child's age. Under subsection J, there is a reasonable likelihood based on the conduct or capacity of the child's parent that the child would be harmed if the child is returned to the home of the parent. I also find clear and convincing evidence here. And I think this one is the easiest one to see how the evidence all fits together. There is a serious risk of harm in turning over a child to a parent who wants to, needs to, has turned a blind eye to physical abuse in the home. To a parent who can demonstrate that he has some parenting abilities, but disappeared for a very significant period of time from this child's life, continues to be arguably disappeared, and that is a huge risk to this child if I were to return him to the care of his father. I have no intention of leaving this child in a situation where he could be physically abused, neglected, or abandoned at any point in time, without any warning, even under the circumstances where he has the supervision of the department, the support of his relatives, and his attorney. So for all those reasons, termination is warranted under the statute. As it relates to the best interest determination, that has to be viewed as far as whether or not there's a preponderance of the evidence that this is in the child's best interest. Clearly, the relatives have provided for this child. The grandparents take care of the child. This is a relative placement, which under the law lends support to giving Mr. Schmidt additional time and opportunity, neither of which he's taken advantage of. This child's been in care for, I think, arguably nearly 2 years. 3/26/22 is when he was removed, and we're coming up on, unfortunately, on the anniversary of that. So he certainly has had an extended period of time to take advantage of that opportunity. Unfortunately, what happened was a fallout, similar, I think, in many ways to the abandonment of his child, was the abandonment of his relationship with his parents, which of course came with it, abandonment of those opportunities that come along with having a child with a relative, especially your parents, frankly. So even though that was the situation, I cannot find that it's something that would hold up termination of his parental rights. He doesn't have a bond with this child. As I articulated earlier, I think that at best he had a pretty good bond for a couple of months when he was engaged in services, frankly, but it doesn't sound like he had much of a bond when the child was at home, and certainly not after he dropped all communication and indicated he wanted to walk away on March 20th, 2023. This child is very young, needs stability and permanency. He's receiving that in the care of his grandparents. He's been able to make leaps and bounds through his early on supports, and is doing well in their care, thanks to the stability and permanency that that household is providing him, which is certainly more stable and permanent than, unfortunately, the home that his father would provide for him. We have the support of our LGAL in requesting the termination of parental rights, as well as our caseworker. The child is too young to really express a preference. The likelihood of him being adopted and adopted expeditiously has been documented on the record by the licensing efforts by the grandparents, as well as confirmation in more than one hearing that that's what their intentions would be, to support their grandchild. So for all those reasons, I do find also there's a preponderance of the evidence here that it serves the interest of the child. I would say is, as it relates to the argument that we may be looking at guardianship in the future, then I think Ms. Bailey-Domansky is going to be looking at some issues as well here with the significant amount of time that she's had to be absent from her child's life, which has a lot to do with her criminal charges. So that's going to be part of the analysis that the court does when I look at whether or not to terminate her parental rights. In all fairness to the child, which is the reason we're here. We need a permanent, stable environment. And we have that with a child who's very well bonded to these parents. And she's going to have some explaining to do as well about how that extended period of absence cannot support termination of parental rights without some significant defense. So I have to look at whether or not we are moving forward towards a permanency goal for this child. And at this juncture, adoption is the most appropriate. It is what the goal currently is, undisturbed from today's proceedings. And in order to do that, we'll need to free him for adoption. And part of that is termination of the parental rights of Aaron Schmidt, which the court will document in an order today, along with relief from the department to provide any additional reasonable efforts or to avoid further removal. We will be mailing out the orders to Mr. Schmidt to appeal if he so chooses. He'll have 21 days to do that with the court supplying an attorney if you're unable to do so financially. And we will require you to show financially that you are unable to afford your own attorney. Arguably throughout the proceedings that have been here, with you working 80 hours a week, there's really an action there from the public defender's office, frankly, that potentially could be instituted, and I'll reserve that to them for reimbursement of attorney fees that have been provided as a result of the public defender's office stepping in where Mr. Schmidt declined to find his own attorney. We'll also be sending him some information about keeping his identifying information current with the Central Adoption Registry, including his right to file the denial of release of that identifying information or to update it as he so chooses. He'll have 21 days to execute that request for attorney and appeal. The case will carry on to the next court date scheduled in April for an additional review and hearing on the termination trial as it relates to Bailey Domansky on April 23rd, 2024 at 1:30. Unless there's any questions, that's all.